Good morning, everyone. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, August 16th, 2023. The time is 9:32 a.m. With us today are Commissioners Emily Lindley and Bobby Janecka, as well as our General Counsel, Mary Smith, and I am John Neerman. For those of you who are joining us virtually, please keep your microphones muted when you're not speaking. For those who will be making presentations, please wait to begin your presentation until our General Counsel or I have asked you to begin speaking. On items where argument or discussion is allowed, we will inform speakers of their time limits. Registration is now closed, but if you'd like to address the Commission on a particular item, please email your name, your affiliation, and the item you'd like to comment on to agenda@tceq.texas.gov. And we will do our best to accommodate that request. And with that, I'd like to thank everybody for being present today. And Ms. Smith, I'll ask you to please call the first item.
The first item is the consideration of the ALJ's proposal for decision and proposed order concerning the application by Restore the Grasslands LLC and Harrington Turner Enterprises LP for new TIPD's permit number WQ00160030001. The applicant should go first, followed by the protestants, the ED, and then OPIC in that order. The applicants or the parties have been provided time as follows: applicants 5 minutes, protestants collectively 5 minutes, the ED and OPIC each 5 minutes. The applicants may save time for rebuttal as they bear the burden of proof on the application. And I believe as a matter of housekeeping, we have some motions for an extension of time to present arguments.
Yeah, thank you, Ms. Smith. We received a motion asking on the part of one or more of the protestants asking for an additional 5 minutes, bringing the protestants' combined time to 10 minutes. I think I understand there was an objection lodged to that. I see a hand up. Let's hear what the objection is, and then, colleagues, we can make a decision on that and then move forward. Good morning.
Good morning, Chairman
And let me ask you just to check your mic and make sure there's a green light on. And if you don't see a green light, press the push button.
I did.
There we go. We got it.
Here we go. My name's Natalie Scott, and I'm here on behalf of the applicants in this proceeding, and I do object to the addition of time for the protestants. They are all on one side, and I have my own side, and I think that they collectively, as the commission and your general counsel has afforded the time, is proper in consideration of the sides of all of the parties, and that's my objection, and I will be happy to answer any questions or.
Thank you, Ms. Scott. I have none. Colleagues, any questions? Okay. Colleagues, my sense is that there is not harm in providing an additional 5 minutes, but I would afford the same 5 minutes to the applicant, so 10 minutes each. Okay.
I'm fine with that.
Agreed. Does that dispose of the sort of timing issues, Ms. Smith?
It does. The first party to present will be the applicant, Ms. Scott.
So we'll have you back up, Ms. Scott, and you will have 10 minutes, and whatever you don't use, you can reserve for rebuttal.
Am I still on?
Yes,
Yes,
we hear
okay.
you.
So my name is Natalie Scott, and I'm here on behalf of the applicants in this called proceeding, which are Restore the Grasslands and Harrington Turner Enterprises. And on May 21st, 2021, my clients filed an application for a new Texas pollutant discharge elimination system to serve their proposed development, which will be a municipal utility district, will be in the future in front of this body. It is at this time a contested case hearing. We don't have a date set on that yet, but that will be coming in the future. In May 2022, the commission granted a number of protestants, including the City of Murphy, the City of Parker, North Texas Municipal Utility District, and some individual protestants, the right to a contested case hearing in this proceeding. In addition to that proceeding, 12 issues were referred to SOA for consideration. We did hold the contested case hearing before SOA, and it was found that my clients, the applicants, prevailed on all of those issues. And the ultimate decision by the administrative law judge was to grant the permit for the wastewater treatment plant, which will ultimately serve the mud creation. And we are standing by that decision and will urge the commission to adopt the ALJ's ultimate conclusion on that. And with that, I will reserve the rest of my time for rebuttal and happy to answer any questions.
Okay,
that you
colleagues,
have.
any questions for Ms. Scott?
Not at this time.
Thank you, Ms. Scott.
And so next, that takes us to the protestants, and we have Lauren Kalasek first.
Good morning.
Good morning. Commissioners, General Counsel Lauren Kalashek with Lloyd Goslink here for North Texas Municipal Water District. The district urges the commission to accept the recommendation put forth by the administrative law judge in the proposal for decision and deny the application on the basis of regionalization for the reasons set forth in the PFD. And we are happy to answer any questions.
Thank you, Ms. Kalashek. Any questions? Okay, I see none. Thank you.
And then we have Art Rodriguez for the City of Parker.
Mr. Rodriguez, good morning. No. Not Mr. Rodriguez.
You just actually called. His son was actually in a car wreck just a minute ago.
Oh, I'm very sorry to hear that.
I'm Luke Olson, I'm the city administrator for the City of Parker. We're just asking that you go with the administrative law judge and go with the denial of the permit and allow us to work with North Texas to get a contract for the connection to the sewer system in that area.
Thank you, sir. I appreciate that, and I hope everybody's all right. Please extend our sentiments to Mr. Rodriguez. Ms. Smith, who's next?
Stephen Dickman for City of Murphy.
Good morning, Mr. Dickman.
Good morning, Mr. Chairman. I'm Steve Dickman, attorney for the City of Murphy. In the very limited time I have, I won't have time to discuss the detailed evidence in the case showing that the proposed wastewater plant will not meet the Texas surface water quality standards. I also don't have time to discuss the regionalization issue, but of course, we do support the ALJ's original recommendation of denial based on the regionalization issue. But I do want to make a few points about the unusual facts of this case that show that Harrington Turner Enterprises is not a legitimate co-applicant, nor will they be a legitimate co-permittee. And so to make those points, I'd like to ask a few questions. Has TCEQ ever before issued a permit to an applicant who certified to TCEQ under penalty of perjury that everything in the application is true and correct, yet did not even read the application? Has TCEQ ever before issued a permit to an applicant who has not even read the draft permit? Has TCEQ ever before issued a permit to an applicant who had no role whatsoever in preparing the application, never engaged the engineering firm that did prepare the application, and never even spoke to or even heard of the engineer who prepared the application? Has TCEQ ever before issued a permit to an applicant who will have no role, responsibilities of any kind regarding the operation and maintenance of the permitted facility. I suggest that if you approve this permit, you will be doing all those things. This TCQ simply cannot, in good conscience, issue the requested permit to Harrington Turner Enterprises, who did nothing to apply for the permit, did not even read the application or the draft permit, has no intention of owning or operating the proposed wastewater plant, and knows nothing about the proposed wastewater plant. Clearly, it is well past time to cease the charade of considering Harrington Turner to be a legitimate co-applicant or a co-permittee. Thank you. I'll be happy to answer any questions you have.
Thank you, sir. Colleagues, any questions for Mr. Dickman? Okay. Ms. Smith?
We have Carolyn Moibes. I'm sorry if I mispronounced.
Mobius.
Sorry.
Mobius.
No
Good
problem.
morning.
Good morning. My name is Carolyn Mobius. I live at 1412 Parkview Lane in Murphy, Texas. I'm an individual protestant pro se in this proceeding. To maintain time efficiency, the following individual protestants, Don Wade Cloud Jr., Ray Hemig, Laura Hernandez, Angelique Longcar, and Kathy Harvey, designated me to speak before this commission on their behalf as well. We stand in opposition to the proposed permit to discharge wastewater into pristine perennial Maxwell Creek. This case is about whether Texas promotes and supports regionalization and whether Texas protects its threatened alligator snapping turtle in Maxwell Creek. What were the intentions of the legislators with the regionalization laws? If this small 100-acre development isn't a prime case for regionalization, what is? This commission does not have an administrative record which supports granting the permit and petition at issue. The record requires denial of the permit and petition. First, as this commission is aware, Section 80.252E provides in part, if the proposal for decision is adverse to a party to the proceeding, it shall contain a statement of the reasons for the proposal, as well as findings of fact and conclusions of law, which support the proposal on any issue referred by the commission or added by the judge. This mandatory requirement was not satisfied in this case if the letter of exceptions is viewed as approving the permit. Specifically, on April 27, 2023, Administrative Law Judge Rebecca Smith issued her proposal for decision order in this case. The PFD remains intact except for changes made by the LJ in her July 20, 2023 letter on exceptions. Please refer to the ALJ's findings of facts 5963-64, which discuss regionalization, North Texas Municipal Water District's designation as regional provider for the watershed at issue, and the ALJ's original statement that North Texas should be instructed to reach an agreement on terms of services with the applicant. Conclusion of laws 17, 20, and 21 include regionalization rules, Texas Water Code 26.081, 30, Texas Administrative Code 351.31.35, and Texas Government Code 311.0162. ALJ concluded the use of the word shall in the rule imposes a duty. On page 45 of the PFD, the ALJ states, despite the ED's argument, the ALJ finds that the rule requires service to be provided by North Texas Municipal Water District, and that granting the application would not be consistent with 30 Texas Administrative Code, Chapter 351, Subchapter C. The ALJ's conclusion of Law 22 and the April 27th PFD with order provide the application should be denied and discussions ordered so that North Texas Municipal Water District alone or with a member customer city can reach an agreement on terms of service. On July 20, 2023, the ALJ issued a letter of exceptions with an amendment to conclusion of Law 22. Other than conclusion number 22, ALJ does not modify any original findings or conclusions which support regionalization. Also, finding of fact number 42 incorrectly states the alligator snapping turtle was not on the threatened or endangered list. This is incorrect according to the record because the alligator snapping turtle is listed as threatened in Texas pursuant to 31 Texas Administrative Code Section 65.175. Indeed, the permit would result in a catastrophic harm to the alligator snapping turtle in Maxwell Creek and its critical habitat. In closing, we respectfully request that Commissioners Court deny the permit and petition issue because granting the permit and related petition would not be consistent with 30 Texas Administrative Code, Chapter 351, Subchapter C. If the commission is inclined to grant the permit and petition at issue, then the commission should adopt original conclusion of law number 22 and or in lieu thereof pursuant to 30 Tax Section 80.265, order the ALJ to reopen the record with specific instructions for further proceedings to ensure regionalization through a tie-in to an existing sewage collection system and full protection of the alligator snapping turtle in the pristine Maxwell Creek from wastewater discharge. Thank you.
Thank you, Ms.
Is there any
Mobius.
questions?
I have none. Colleagues, any questions for Ms. Mobius?
Thank you.
Thank you. Ms. Smith?
Buddy Pilgrim.
Mr. Pilgrim, are you with us today in person or virtually?
Yes. Can you hear me?
We can. Go ahead and identify yourself for the record, and the floor is yours, sir.
Okay. My name is Lindy M. Buddy Pilgrim. I live at 3106 Bluff Lane in Parker, Texas. I'm an individual protestant, and I would encourage, before any of the commissioners make a decision on this, that you read the entirety of my May 17th exceptions to the April 27th flawed proposal for decision. There's a link to it on the agenda to this. It covers the issues that I don't have time to cover by listing them today. Issue H in particular, accuracy and completeness of the application. The AJL's only statement regarding that refers to an ED witness, Martinez, who deemed the application to be complete. He never reviewed it for accuracy. He just deemed it to be complete. My exceptions list 24 material errors, inaccuracies, and incomplete portions of the application. Also read my footnote number 1 of my exceptions, which refer to the land actually not being owned by the entities who are applying it at the time the facility will be built. There is no time at which a facility will exist on this property that will be owned by either Harrington Turner or by Restore the Grasslands. It's going to be owned by an entity specified in the deed to transfer the land, an entity that's owned by 2 trusts of Don and Philip Huffines. Family trusts of Don and Philip Huffines are the entities behind this entire endeavor, and not Restore the Grasslands, which is a shell corporation. Also, the administrative law judge used a bizarre definition for the definition of facility as including contiguous land and fixtures used for. And I stress that it has a conjunction in there, land and fixtures used for. Since no fixture structures or apertures exist yet, Harrington Turner only owns the land, and there are no fixtures, apertures, or structures that are used for storing or processing of waste treatment. So therefore, they are not a proper applicant for this particular permit. The administrative law judge also flipped the burden of responsibility in terms of proving that Harrington Turner was a legal entity at the time of the application. Harrington Turner was not. Its general Harrington Turner Enterprises LP is a limited partnership whose general partner had forfeited their right to transact business in Texas in 2012, and that right to transact business was not restored until December 2021, and they did not prove during the hearing that they were actually a legal entity at the time the application was made. Yet the administrative law judge seemed to have put the burden on us that we had to prove that they were not legal. The Secretary of State records will prove our fact.
And Mr. Pilgrim, your time's expired, but if you have a thought to finish up, you can go ahead and do that.
Main thing is just these are not the legal entities that should be making this application, and I don't think it's what the Texas legislature ever intended, that entities that are hiding behind the trust of the Don and Philip Huffines families, hiding behind 2 shell entities, should not be granted a permit to put a wastewater facility in the backyard of other citizens.
Thank you, sir. Colleagues, any questions for Mr. Pilgrim? Ms. Smith?
And finally, for the protestants, we have Andrew, and I'm very apologetic. I think I'll get this name wrong too. Malchewski.
Mr. Malczewski, are you with us?
Hear me?
Yeah, we can
Yes.
hear you. Go ahead and state your name for the record, and then the floor is yours, sir.
My name is Andrew Malczewski. I live at 1328 Thornwood Drive in Murphy, Texas, adjacent to the property or proposal land that's being discussed. And I'll be really brief, and I appreciate you allowing me to speak for a few minutes. As a resident of Murphy, next to this land, this proposal for the wastewater treatment plant basically goes against thousands and thousands of residents all surrounding this plant that's being proposed. There's real issues with how toxic it may be to children that play in the Maxwell Creek that runs from the proposal discharge point down for about 2 miles to the entire city of Murphy. City of Murphy parks and athletic fields are lining Maxwell Creek. And I personally, I used to coach a lot of soccer for little kids. Balls go into the creek all the time. We have to go fish them up, pick them up. Children touch the balls. I can't imagine E. coli on those balls and kids touching those balls and touching their faces. That's kind of my personal story. I know there's a level of E. coli that's admissible by the state of Texas, but given the regionalization, I don't think that we need to risk having any kids getting sick because the developer wants to be greedy and wants to go through this crazy proposal here as opposed to trying to figure things out with regionalization through the city of Murphy or Parker or any other entity that's available in surrounding community. I ask that this proposal be denied for the sake of the residents of the state of Texas. Thank you.
Thank you, Mr. Malczewski. Colleagues, any questions? Seeing none, thank you, sir.
And we have the ED next.
Good morning, Commissioners, General Counsel, Public Interest Counsel. I am Kathy Humphreys of the Environmental Law Division. With me today is Feroz Vahora and Peter Schaefer of the Water Quality Division. The Executive Director respectfully recommends the Commission adopt the ALJ's alternative recommendation in the PFD and grant the permit as drafted with the additional requirement that the applicant install carbon scrubbers and partially enclose the wastewater treatment facility. The Executive Director also recommends the Commission adopt the proposed changing to the findings of fact and conclusions of law noted in the ALJ's exceptions letter. Turning to the regionalization issue, at the hearing on the merits, Mr. Martinez testified that the Executive Director requires applicants for TPDS permits to provide certain information regarding the neighboring wastewater treatment facilities. Mr. Martinez testified that if there are any permitted domestic wastewater treatment facilities within a 3-mile radius of the proposed facility, the applicant must provide information regarding whether the wastewater treatment facilities have sufficient existing capacity to accept the additional volume of wastewater. According to the information provided by Restore the Grasslands in its application, the City of Allen, the City of Lucas, the City of Parker, and the City of Plano all indicated that they were either not willing to serve the proposed development or they did not respond to the applicant's request for service. As provided in applicant's Exhibit 18, North Texas Municipal Water District is a wholesale provider of wastewater and does not directly provide service to developers or residents. Therefore, Restore the Grasslands cannot obtain service directly from North Texas. Instead, Restore the Grasslands would have to become a customer of either the City of Parker or the City of Murphy. The city's sewer systems would transport the wastewater from the development to a North Texas wastewater treatment plant for treatment. Additionally, during the hearing, some of the parties argued that 30 TAC Section 351.35 regarding the designated regional entities applies to this application, and thus the application must be denied. The Executive Director disagrees. The Water Code is clear that the Texas Legislature encourages regionalization. However, Chapter 26 of the Water Code falls short of mandating regionalization in every case. The Executive Director acknowledges that 30 TAC Chapter 351, Subchapter C, provides that North Texas is the regional provider in the area. However, as I just mentioned, North Texas is unwilling to provide service directly to Restore the Grasslands. As such, North Texas is effectively not available as a service provider to Restore the Grasslands in this case. Because the neighboring cities are unable or unwilling to provide service or access to their collection systems without conditions, Restore the Grasslands is put in the position of not being able to obtain a TPDS permit to provide wastewater service to its development because North Texas is a regional provider, but North Texas will not provide service directly to Restore the Grasslands because Restore the Grasslands is not a North Texas customer or customer city. Ideally, Restore the Grasslands would be able to tie into one of the neighboring wastewater collection lines. However, the neighboring cities have all either denied service to Restore the Grasslands or conditioned service on land use controls, including density. Therefore, the executive director recommends the commission issue the permit as drafted with the addition of new other requirement number 8. Thank you, and we're available for questions.
Thank you, Ms. Humphries. I have none. Colleagues, any questions? Seeing none.
OPIC.
Yes, good morning, Chairman, Commissioners, General Counsel, and the Executive Directors, attorneys, and staff. I'm Sheldon Wayne for the Office of Public Interest Counsel. I would like to begin by first highlighting the complexity of this case, noting that it featured 12 referred issues and a large contingent of protestants, including 2 cities, 1 water district, and many pro se litigants. After consideration of the record in this matter, including testimony, exhibits, and argument, OPIC maintains the position taken in our closing brief, that the applicants met their burden on 11 of the 12 referred issues, but did not meet their burden with respect to proving that they complied with the Commission's regionalization requirements. Therefore, OPIC agrees with the administrative law judge's conclusions and primary recommendation in its proposal for decision that the application be denied and that the applicants in North Texas Municipal Water District be ordered to agree on terms for providing wastewater service, with the understanding that if the parties are unable to come to an agreement within a reasonable time, the Commission will set those terms of service. Here, the issue of regionalization was rather novel, as in addition to the generally applicable regionalization requirements contained in Chapter 26 of the Water Code, this facility was also subject to the requirements of Chapter 351, Subchapter C of the Texas Administrative Code. Subchapter C designates North Texas as the regional provider for the watershed area, which includes the location of the proposed facility. TCEQ rules require that North Texas provide wastewater collection and treatment service to all entities that require it within its defined watershed area, upon such terms as may be agreed upon by the parties or as may be ordered by TCEQ in the absence of agreement. What complicates this situation is that while North Texas has the capacity to treat the applicant's wastewater, it does not operate its own collection systems. Instead, member cities, including Murphy and Parker, operate their own collection systems and convey the waste to North Texas's system for treatment. Therefore, it seems that applicants would need to tie into one of the city's systems for conveyance of the wastewater to North Texas for ultimate treatment. Further, it appears that prior to litigation, both Murphy and Parker indicated to the applicants that they would only provide collection services to them if they agreed to certain land use restrictions, which the applicants would not agree to. We recognize that this is certainly an unusual position that the parties have placed themselves in. However, in OPIC's view, the applicable rule language is clear, and its obligations are not changed by the actions or inactions of the parties. The rule unambiguously mandates that North Texas provide services to the applicants, and it should be required to do so upon terms either agreed upon or set by the Commission. Finally, while OPIC is recommending permit denial, if the Commission disagrees, OPIC alternatively recommends that any permit include the special conditions related to the installation of carbon scrubbers and partial enclosure of the plant, as agreed to by the applicants during the hearing. Thank you, and I'm available for any questions.
Thank you, Mr. Wayne. Colleagues, any questions for OPIC? Seeing none.
And then Ms. Scott has 7 minutes and 40 seconds left for rebuttal.
And Ms. Scott, as you're walking up, I'll just observe, I misheard you perhaps in your opening statements, but to be clear, the ALJ's proposed order is to deny the application based on regionalization.
That was the initial, I'm on. I think I'm on. Yes, but in the ALJ's July 2023 exceptions letter, what the ALJ said with regard to paragraph 22 is that the draft permit should be issued as proposed with the addition of new other requirement 8 as follows. And that would be what the OPIC council just discussed with the addition of the buffer zone requirements, and that the permittee shall install carbon scrubbers to the facility and cover portions of the facility where the largest odor emissions are likely to occur.
Thank you for that. I appreciate you answering my question. I'll ask the clerk not to hold that time against you, and you
Okay.
can go ahead and
Sure.
give us your rebuttal.
Yes, and to be clear, with regard to the applicant, there are dual applicants here. The first applicant, which is statutorily required, is the landowner. And the landowner of this property is Harrington Turner Enterprises. And during the course of the contested case hearing, it was determined by the administrative law judge that Harrington Turner Enterprises is a legitimate business that is licensed to operate in the state of Texas, and I don't think that there is any question with regard to that. The co-applicant is an entity called Restore the Grasslands, and Restore the Grasslands is the co-applicant because it will be the ultimate developer with this property. And they petitioned for this permit as co-applicants so they could provide the ED and the commission with all of the information that was necessary to grant the permit. And there was a draft permit that was granted. Of course, we went to the contested case hearing, and it was found that we met all of the burdens of the 12 issues that were referred to the administrative law judge. And so, yes, Chairman, to your question, the initial PFD did recommend denial of the permit subject to an agreement with the North Texas Municipal Water District to directly provide service to the property in question. We have certainly reached out to, and I'll call it just North Texas for the record, and North Texas is unwilling and unable to provide service directly to this property based on what their rules and, as I understand, their understanding of the regionalization standard in the state of Texas. And to the ED's comments, yes, it is encouraged, but it's not mandated. And according to the North Texas Municipal Water District, they can only provide service to the proposed MUD through either a member city or a customer city. So we are in currently, and this is subject to the law that changes on September 1st, to opt out of a city's ETJ, but the property that is the subject of this permit is currently in the City of Parker's ETJ. It is not within the City of Murphy's ETJ. It is adjacent to the City of Murphy. So I would give probably some weight of evidence to, you know, the City of Murphy's credentials as, you know, their opposition. But the City of Murphy and Parker are both, they're not member cities under North Texas, but they are customer cities under North Texas. Both of them are unwilling to provide wastewater service to the proposed development. So the alternative for us, for my client, if you can't pursue regionalization through, and I understand that it is encouraged by the state of Texas, but it's not mandated. And so if a member city, such as Parker or Murphy, won't provide that service, then the option for the developer is to pursue a wastewater discharge permit, which is what we've done in this situation. And you know, to the Public Interest Council's point, this is an encouragement, but in the original PFD, the ALJ's recommendation was that the permit be denied if we could not reach an agreement with North Texas, or if you, as the commission, did not order North Texas to provide service. And I believe that an order for North Texas to provide service would be a real shift in policy in regard to how wastewater is available to developers, especially in this area of the state, in the North Texas area. And it would be a shift from a mandate to from an encouragement to a mandate. And that's a large, I think, burden for North Texas. I think it is a change in the way that developers would pursue creation of municipal utility districts and how you have the, available comparable service. So I will again point you to the July 2023 ALJ's letter that did remark that the draft permit should be issued with proposed issue with the addition of new other requirements. And this is something that my client testified to at the contested case hearing, that they would be willing to add additional buffer zone requirements and to install carbon scrubbers to the facility and cover it. So one of the biggest concerns that were raised by the protestants was odors, and I think that would address those issues and allow the client to move forward with the development as contemplated under the state's regionalization policy and under the rules for permitting of a wastewater discharge plant. And so with that, I would encourage you and urge you and move that the commission adopt grant the wastewater discharge permit.
Thank you, Ms. Scott. Colleagues, any questions for Ms. Scott? All right, thank you, ma'am. Appreciate it. So in my view, colleagues, this issue really turns on the question of regionalization. I don't have any reason to change the ALJ's conclusion that the applicant has otherwise met its burden. And at the heart of the matter is our interpretation of 30 Texas Administrative Code, Section 351.35, which states that an area-wide system such as the North Texas Municipal Water District, quote, shall provide regional wastewater collection and treatment service, end quote. And that's either upon agreement by the parties or as may be ordered by the commission. And so the question is, what do we mean by the word shall? And I think it's clear, not only from agency practice, but more importantly from the statutory context, that the term shall does not mean that the commission must deny the TIPD's application within an area that's designated for an area-wide system, or that the commission must order an area-wide system to provide service. The way I read it, it means that the area-wide system must provide the service upon a proper showing and a lawful order by the commission. And I'm not going to do an exhaustive survey of the statutory context, but I'll point to a few. Texas Water Code Section 26.084A states that the commission, quote, may refuse to grant a permit, end quote, in an area designated for an area-wide system. And subsection B identifies conditions precedent to such a refusal, and those include the agreement of the area-wide system to provide that service, and that the refusal does not result in an undue financial hardship. Additionally, sections 26.003 and .081 express a legislative intent to encourage and promote regionalization, but not to require it, not to mandate it, as Ms. Humphreys noted. Section 26.0282 states that the commission, quote, may deny a proposed permit based on regionalization. And then looking at the Texas Code Construction Act, I think Section 311.021 is also instructive. It asks for it presumes a just, reasonable, and feasible result. In my mind, the TIPD's application process has to be something more than just merely a forum to negotiate the terms of service from an area-wide system. I think there is a possibility, and I think that this case presents facts that support that possibility, that other systems will be permitted within those areas. All of that is to say that the commission is not bound by the word shall in the way that the ALJ reads it, and that we need to look at this term in its statutory context. So to reach the correct result on this record, we have to weigh the facts. And here's how I read those facts. First, the applicant sought service from North Texas Municipal Water District and several other potential providers in the area. The North Texas Municipal Water District refused to provide service directly to the applicant. The only other providers that were willing to provide service are the cities of Parker and Murphy, but they would do so only with a density requirement that are not economically feasible for the applicant. And I am not comfortable denying the permit on those facts. And in fact, I would vote to grant it. And let me pause there. Commissioner Lindley?
Thanks to everyone for laying this out, especially pro se people. This is tricky, a really tricky one. I think you said everything I would say. If I were just going to briefly put it in my own words, and I had to get notes for myself on this one because it was so challenging. So I'm going to read from a few notes so I don't say anything wrong. But I think the ALJ's got everything right, but regionalization. And I think your laying out of the facts was accurate. This one just got real complicated in interpreting laws and rules, but I disagree with the ALJ's interpretation that the regulations establishing North Texas as a regional provider impose a duty on TCEQ to then require service by the regional entity in all circumstances. I should probably stop there and just say you did a good job laying it out, and I would agree with you.
Thank you, Commissioner. Commissioner Janeka?
I don't think I could make any points that would improve either of the two that each of you made, and I'm entirely in agreement in as to the appropriateness of overruling the ALJ's decision and supporting issuance of the permit.
I'd like just to make one note before I ask for a motion, and I'm not going to order a discussion between the parties here. I know this case has been hard fought. It will probably continue to be hard fought, and there's probably quite a bit of emotion around that, I would imagine. And at the risk of sounding naive, despite that, I'm going to encourage the parties to get together and see if they can come to a resolution on this, not ordering those discussions, just encouraging those discussions. I think regionalization would be the better outcome if it can be achieved. We're just not going to force that result under the current statutory context that we're dealing with. So with that hopeful request in mind, colleagues, I think we're ready for a motion.
I completely second that. I think Kathy, representing the ED, said it well, which is what you were saying, that ideally, the parties can come to an agreement and the city can be a provider, thus, North Texas be a provider, but that's for them to work out. I have a motion. There's a little bit of cleanup that I'm going to need to read off in my motion. So it's a little long, but I can start it if y'all are ready. And because it is long, if I say something wrong early on, please interrupt me because I might not see your hand come up because this is technical, so I'm going to have to read it. But with that, I move that we adopt the ALJ's proposed order as revised in the ALJ's letter dated July 20th, 2023 with the following modifications. Delete finding of fact number 64. This change is made to remove a finding of fact that draws a legal conclusion and mischaracterizes applicable law. Add new conclusion of law number 18A. Quote, applicants satisfied Texas Water Code section 26.0282 regionalization requirements, end quote. This change is made to correctly state the Commission's interpretation of applicable law. That we add two new conclusions of law to be numbered conclusions of laws numbers 18B and 18C, as recommended by the Executive Director in her May 17th, 2023 exceptions to the ALJ's PFD. And those conclusions of law read like this. New conclusion of law number 18B, quote, the purpose of Chapter 26, Subchapter A is to encourage and promote the development and use of regional and area-wide waste collection, treatment, and disposal systems to serve waste disposal needs of the citizens of the state and to require the use of all reasonable methods to implement the policy. Texas Water Code Section 26.003. A new conclusion of law number 18C to read, quote, the phrase encourage and promote as used in Texas Water Code Section 26.003 is permissive. Texas Water Code Section 26.003, end quote. These changes are made to correctly state the regulatory framework established for TCEQ's regional policy. That we add new conclusion of law number 21A to state, quote, 30 Texas Administrative Code Section 351.35 imposes a duty on North Texas Municipal Water District to provide regional wastewater collection and treatment service to all legal entities requiring such services within the defined area, if so ordered by the TCEQ under its authority in Texas Water Code Sections 26.081 through 28.086. Texas Water Code Sections 26.081 through 28.086, 30 Texas Administrative Code Section 351.31. 0.35. I believe I've said that correctly. This change is made to accurately state the Commission's interpretation of applicable law. Add new conclusion of law number 21B to state, quote, 30 Texas Administrative Code Section 351.35 does not impose a duty on TCEQ to require service by a regional entity in all circumstances. Texas Water Code Sections 26.081 through 28.086, 30 Texas Administrative Code Section 351.31.35. This change is made to accurately state the Commission's interpretation of applicable law. And lastly, that we modify ordering provision number 1 to state that the application is granted. This change is made to effectuate issuance of the draft permit consistent with the Commission's decision on this matter. That we issue the ED's draft permit as modified by the Commission's order, and that we adopt the ED's response to comments.
I second that motion.
Can we pause for a minute?
Yes.
Because I think
Did I say something?
it's my error. But
Oh.
but at every point where it says
0.081
26.081 through 28.086, it should be 26.086.
I was, okay, yeah.
And
Do I amend my motion? Or can someone amend it? Or can I say on the record that anytime I
I
stated?
think we can consider that a
Okay.
friendly amendment if you just want to just state what the amendment is.
The amendment would be that anytime I said 26.081 to 28.086, the intention for the record is 26.081 to 26.086, which I believe I stated at least twice.
And then at one point, you talked about the TCEQ's regional policy rather than regionalization, but I think
I
you
do mean
meant
regionalization. Thank you.
Okay, I think we can consider both of those friendly amendments to not force you to
Thank you.
reread your motion. And then I just had a clarifying question. I want you, Ms. Smith, if you can, confirm my understanding that by moving to adopt the proposed order as revised by the ALJ's July 2023 letter, that the order would include the special conditions that have been described concerning scrubbers and so forth?
That's correct.
Okay, it's my understanding that that should be part of the order, so I just wanted to make that clear. All right, I think we have a motion. I think we have a second. I think we have two friendly amendments. I believe we're ready to call for a vote. All those in favor say aye.
Aye.
The motion carries. Thank you all. Ms. Smith, when you're ready, please call the next item.
Item number 2 is the consideration of the proposal for decision and proposed order concerning the petitions for the creation of Lakeview Municipal Utility Districts 1, numbers 1, 2, and 3 of Ellis County. The parties have been notified that the petitioner and the protestants will have 10 minutes of oral argument time, while the ED and OPIC will each have 5 minutes of oral argument time. The petitioner will speak first and followed by protestants, ED, then OPIC, and the petitioner may reserve time for rebuttal as they bear the burden of proof in this matter.
And Ms. Scott, I think you have your work cut out for you this morning.
Yes, sir, I had a sleepless night.
I can imagine.
So, I'm here, Chairman and Commissioners, and it is actually my honor to represent a true Texas land owner. And this is a landowner who has held this property in generations. And through the policy of the state of Texas and certainly statutory policy through creation of MUDs, and with recognition of the legislature, this is a landowner who can pursue the highest and best use of its property. And given that I'm resorting to some policy implications, I would give the chairman and the commissioners what I believe is relevant public policy with regard to this issue. Municipal utility districts have been available to landowners in Texas for decades, and they have been summarily successful in the state of Texas. And this is something that the Texas legislature has honored through over, the initiation of MUDs in the state and through the Texas Constitution. And these landowners have been placed in a unique situation because prior to 2019, if they wanted to develop this property, it could have been unilaterally annexed into the city of Waxahachie because it was in the city of Waxahachie ETJ. But in 2019, the Texas legislature, with the blessing of Governor Abbott, restricted the ability of cities to unilaterally annex land into the corporate limits of the city, land that was in the ETJ. And that gave landowners an opportunity, as you would think, given the will of the legislature and Governor Abbott, to develop their property as they saw fit with their highest and best use. But since that time, the cities have done their dead level best to still impose development restrictions, density restrictions, and those types of things on land that is currently within their ETJ. And as I mentioned previously, that law is about to change, and landowners can opt out of the ETJ. That's not available to this applicant at the time, or at the time that the application was filed. But if we're looking at real Texas policy, and if we're considering the PFD in this situation, and it is regarding costs of the wastewater discharge plant only, And what the ALJ found was that the costs were too high. But if you step back and look at that, the costs are what they are. And I'm sure that the ED will make this point also. But when the ED considers the application for a mud creation, and this is going back decades, it is considered at the time that the application is filed. And of course, the protestants have the opportunity 2 years later, when this comes to a contested case hearing, to say, oh, well, now costs have increased. Well, of course they have, and we recognize that. But also, home price sales have increased, and it's an offset into those considerations. Not only that, but there is a developer contribution, and the ALJs note that there was a thought that, oh, well, maybe this development is going to take place and there won't be services available to the landowners is erroneous as far as I can tell, because that cannot happen. That cannot happen. The way that the statute, the way that policy works, is that the application, and let's be clear, this is not imposing additional regulatory controls over any piece of land in the state of Texas. What we are only asking from the TCEQ is to draw a boundary around a landowner's piece of land and say, we've given you basically a governmental entity, and what you can do now is provide financing. That is the only thing that we are asking approval for. We are asking for the landowner to be able to provide financing for water, sewer, drainage, and roads. We should not be imposed any additional regulatory guidelines or lessened any regulatory guidelines. It is the same for any development, whether a MUD is placed over that district or not. This is the same development that would occur if you are financing it through a MUD or financing it through the developer's own hands.
That's 6 minutes.
And I will end with that, and I will come back for rebuttal. But the financing mechanism is a benefit to the home buying consumer. This is a policy of the state of Texas. We actively pursue corporate relocations. And if people are moving into the state of Texas, they need a place to live. And they need a place to live that is affordable, that has good amenities, that is a place for their family, that has green space, that has amenities, and that is affordable to the home buying consumer. And if we upend this, if you approve this PFD, it will be upending decades of MUD creations in this district and in this state, and setting what I believe to be a very dangerous precedent.
Thank you, Ms. Scott, and we'll hear from you again on rebuttal. Ms. Smith?
We'll begin with Emily Rogers.
Good morning, Ms. Rogers.
Good morning. How are y'all today? For the record, my name is Emily Rogers, and I'm going to need these. I represent the city of Waxahachie and Ellis County in this matter. My clients agree with the ALJ's recommendation to deny the applications pending in this matter. The applications for Lakeview MUDs 1, 2, and 3 grossly underestimate the cost associated with the construction of the wastewater treatment plant for the proposed project. The applicant estimated that the wastewater treatment plant would only cost $1.75 million, but the expert for the county and the city estimated the cost to construct the plant was about 15 to 20 times higher. This is no small discrepancy. Thus, the applicant failed to establish the projected construction costs are reasonable. But there are other reasons these applications should be denied. A MUD is particularly advantageous to a landowner developer, as it will enhance the value and marketability of the developer's property, and the developer will be reimbursed by the MUD for the costs associated with the construction of the infrastructure. MUDs also have the power to condemn property, levy taxes, enter private and public property, employ law enforcement, in addition to providing water and wastewater services. Conversely, the development within a MUD can have negative impacts on the surrounding land and natural resources. Thus, in order to balance these competing interests, the Texas legislature adopted Texas Water Code Section 54.021, which lays out what the commission must consider when granting or denying an application for the creation of a MUD. Texas Water Code Section 54.021 requires this agency, in determining if the project is feasible, practical, necessary, and would benefit the land, to consider whether district and subsequent development would have an unreasonable effect on several things, including natural runoff rates, drainage, water quality, groundwater levels, recharge, subsidence. And this agency must also consider the availability of comparable services. The evaluation of these factors under Section 54.021 should not be based on cursory or conclusory information or the blind acceptance of information contained in the MUD creation applications. The review should not be based on estimated, preliminary, or tentative plans for development. No real analysis under Section 54.021 can occur based on tentative, preliminary, or estimated plans or information. Additionally, this agency shouldn't abdicate its responsibilities to ensure a district will not have unreasonable effects on other jurisdictions or other entities. For these reasons, the county and the city urge this commission to adopt the city's and county's exceptions to the PFD. I'm going to address some of those exceptions, starting with the runoff rates and drainage. There is nothing in the MUD's applications that state what the natural runoff rate is on the property, so there's no information or evidence about how the development will impact those rates. Nevertheless, the evidence was uncontroverted that the portion of the development that drains to South Grove Creek will be redirected to Long Branch Creek, and thus Long Branch Creeks will experience increased flows. There's no information in the record about how that additional increased flow will be addressed. With respect to water quality, the MUD's applications do not address water quality at all. The uncontroverted evidence shows there will be an increased runoff of nutrients into receiving streams that are already barely meeting water quality standards. Simply deferring to local authorities on this issue is not what the statute provides. Moreover, there was no review of the local regulations to even determine if their regulations require stormwater quality controls or whether those regulations are applicable in the ETJ. Again, these MUDs are being created to the advantage of the landowner, and that's why there's this balance under 54.021, and those reviews should not be cursory. For these reasons and the other reasons outlined in our exceptions, the city and county request that the commission adopt their exceptions and deny the applications as recommended by the ALJs. If I have any questions, I'm happy to answer them.
Thank you, Ms. Rogers. Colleagues, any questions?
Okay, thank you.
Seeing none, thank you.
And then Eric Allman for the protestants.
Good morning, Mr. Alman.
Good morning, Chairman, Commissioners, General Counsel, Public Interest Counsel. My name is Eric Allman. I'm here on behalf of Wesley Tron, Sharon Tron, and other true Texas landowners who live adjacent to this facility. The decision before you here today is whether to create new property taxes and expand the size of government. The statutes do not simply allow this to be done without the applicant meeting certain burdens. This is not a Senate Bill 709 matter. There is no presumption in favor of the applicant in this matter. Rather, this is like a judicial proceeding, where the moving party, the plaintiff, has certain elements that they are required to prove in order to prevail in the case. Here, the judges have lifted the Senate Bill 709 standard and have applied it to a non-709 matter. They have presumed that the applicant is correct, and there are two particular issues we would point out where this has been the case. With regard to the impact of this on groundwater, there are certain considerations that are supposed to be addressed by an applicant. In the application, the applicant said, well, no groundwater is going to be relied upon for the subsequent development here, so we don't need to address groundwater. That position was recanted by the applicant's expert at the hearing who, when presented with the evidence that groundwater would be relied upon by the water service provider, admitted, yeah, you're right, groundwater is going to be used, but no analysis was presented by the applicant of the impact this would have on groundwater. The ALJs looked at this and they said, well, but the protestants didn't present evidence. The protestants didn't come in and show us how this is going to happen, exactly how much is going to be used. That is placing the burden on the protestants in the matter. When you're not in a 709 context, the courts have said in court, you do not place the burden on the non-moving party because that simply creates a second bite at the apple for the moving party to come back in rebuttal and meet their burden of proof that they should have met the first time around. In addition, with regard to the roadway powers, your rules require a map of all road facilities that will be developed within the boundaries of the MUD. This was not provided. That's beyond dispute in the record. There's no representation that a map of all road facilities was provided. The ALJs again looked at this. They said, well, we're going to accept the applicant's representations, which is not clear what representation is being referred to because there's never even a representation that map was provided. And they said, but the protestants didn't provide evidence on this issue. The protestants didn't come forward and show us, I'm not really sure what they were looking for, but they said protestants didn't present evidence on this issue. Thus, the applicant prevails on this issue. This is not the proper approach. The proper approach is to place the burden on the applicant on each issue, each term required, and that was not done in this case. It would be legal error to attribute that burden in that manner. We ask that the application for the MUD be denied. Thank you.
Thank you, Mr. Allman. Colleagues, any questions or comments for Mr. Allman? Thank you, sir. Ms. Smith?
The ED.
Good morning, Chairman, Commissioners, General Counsel, Office of Public Interest Counsel. My name is Kayla Murray, and I'm an attorney in the Environmental Law Division representing the Executive Director. With me today is Bobby Salehi, also an attorney in the Environmental Law Division, and Justin Tack, manager of the district section. The Executive Director respectfully recommends that the Commission issue the Lakeview MUD orders as drafted by the Executive Director and create the districts. The petitions are in compliance with all applicable statutory and regulatory requirements. The ED recommends that the Commissioners reject the proposals of the ALJs in their proposal for decision and create Lakeview MUD numbers 1, 2, and 3. Pursuant to Texas Water Code Section 54021A, the Commission shall consider the following factors when determining if a MUD should be created: the availability of comparable service, the reasonableness of projected construction costs, tax rates, and water and sewer rates, and lastly, whether the district will have an unreasonable effect on the following: land elevation, subsidence, groundwater levels, recharge capability of a groundwater source, natural runoff rates and drainage, water quality, and total tax assessments on all land located within a district. The ALJs concluded that the applicant met all of these requirements except for the reasonableness of projected construction costs, specifically those costs related to construction of the wastewater treatment plant. In the ED's exceptions to the proposal for decision, we emphasize the following authoritative language. 30 Texas Administrative Code Section 29311D, which lists the petition requirements for MUD creations, refers to a statement of the estimated project cost. 30 Texas Administrative Code Section 29311D5 lists the requirements for the preliminary engineering report. 29311D5 also states that tentative itemized cost estimates of the proposed capital improvements and itemized cost summary for anticipated bond issue requirements should be included in the preliminary engineering report. As illustrated by these rules, the district creation process is based on cost estimates that are preliminary and estimated at the time of application. The projected construction costs will undoubtedly change over time, as they inevitably have in virtually every district creation application that has been submitted to the TCEQ. Additionally, the final cost for the wastewater treatment plant cannot be determined until the TPDS permitting process is completed in another process altogether. It is likely that the construction costs for the proposed wastewater treatment plant will change as a result of that TPDS permitting process, which is precisely why the construction costs provided in the MUD application are referred to as an estimate in the TCEQ's rules. The ALJ's alternative recommendation that the applicant provide updated cost estimates not only lacks any authority in the TCEQ's rules, but it also raises several unanswered questions. When are these updated costs to be submitted? Every time there is a change in cost, or every time there is a change in cost that exceeds X number of dollars. What would that amount be? How would that amount be determined? The ED's position has remained the same since the August 3rd, 2021 technical memorandums for these applications were issued, and that is that the proposed construction costs included in the applicant's preliminary engineering reports are reasonable, and as a result, the ED has found that the TCQ requirements on this issue are satisfied. With the remainder of the other district creation factors also being satisfied, the ED recommends that the commission grant the creation of the 3 Lakeview MUDs. Thank you, and we are available for questions.
Thank you, Ms. Murray. I have none. Colleagues, any questions? Seeing none? Mr. Wayne, you also have your work cut out for you this morning.
Yes, certainly a busy last couple of days, Chairman.
Did you sleep last night?
Luckily I was able to get a good night's sleep, so I was lucky in that respect. Well, good morning again, Chairman, Commissioners, General Counsel, and of course the Executive Directors, attorneys, and staff. For the record, I'm Sheldon Wayne with the Office of Public Interest Counsel. With the exception of a few requirements that OPIC did not take a position on, we originally found that the applicant had met its burden of proving that the proposed MUDs meet all applicable legal requirements. However, after considering the judge's proposal for decision, OPIC now amends its position and concludes that the applicants have not demonstrated that the proposed construction costs are reasonable and as such have not carried their burden. Therefore, consistent with the judge's proposal, OPIC respectfully recommends denial of the petitions, or, in the alternative, that the applicants be required to provide updated cost estimates, including reasonable cost for a wastewater treatment plant. Here, part of the Commission's inquiry into a proposed district is whether the project is feasible, practicable, necessary, and will benefit the land to be included in the district. In making this determination, the Commission shall consider projected construction costs, tax rates, and water and sewer rates. In this case, the applicant submitted the district's proposed construction cost in 2021 and included an estimate of $1.75 million for a 1.1 million gallon per day wastewater treatment plant. However, during technical review of the petitions, the capacity was increased to 1.59 million gallons per day to account for commercial use, but the cost estimate was never revisited. Additionally, over the past couple of years, construction costs have increased sharply. In contrast, the protestants provided uncontroverted evidence that a 1.59 million gallon per day plant would cost between $29 and $37 million to construct. While OPIC was troubled by the discrepancy in construction costs, we originally took the position that the underestimation did not necessitate a finding that the projected construction costs were per se unreasonable. Our principal justification for this was that because the developer must pay all upfront utility costs and can only be reimbursed up to what is allowed under the maximum $1 tax rate per $100 valuation, any upfront increase in the cost of a wastewater treatment plant will be borne by the applicant and/or the developer, and importantly, not by the district residents. However, after review of the proposal for decision, we are persuaded by the administrative law judge's reasoning that the reasonableness of construction costs must stand on its own and not be viewed simply in terms of the ultimate tax burden on district residents. The ALJ appropriately recognized that if a developer vastly underestimates construction costs, there's a risk that it may not be able to fully fund the project and the development could be abandoned before completion. Based on this, the ALJ found, and OPIC agrees, that the applicants have not carried their burden of proving that the creation of the districts are feasible and practicable because the applicants did not provide reasonable construction costs. For this reason, the petitions for creation of the MUDs should be denied, or alternatively, the applicant should be required to provide updated cost estimates. Thank you, and I'm available for questions.
Thank you, Mr. Wayne. I have none. Colleagues, any questions for OPIC?
No questions. I did want to share the observation. In my opinion, this was a matter where the record was notably improved by OPIC's participation in that process, for what it's worth.
Thank you very much, Commissioner. We appreciate that.
Thank you, Commissioner. Well, I really appreciate the arguments this morning. I
Ms.
appreciate.
Scott still has some
Oh,
rebuttal.
forgive me. Yeah, Ms. Scott. I was getting ahead of myself. You have 3.5 minutes left.
Well, thank you, Chairman, and I'm dying to address some of these issues. The single failure that the ALJ found in the applicant's application was the construction costs of the wastewater discharge plant. And I will tell you that the costs are what the costs are. And I agree with the ED that those costs are determined at the time that the application is submitted. Of course, things will change over time. Construction costs will change. Maybe there's a recession, but this agency can't be charged with a constant review of costs. I mean, when does it end? What is the burden on the developer? What is the burden on staff to continually review these costs? The bar that is raised at the time that these things really have to be considered as at the time of bond issue and at the time that the district is created. And again, this isn't putting additional regulatory controls or lessening regulatory controls. It is just drawing a boundary around a landowner's property that says, yes, it seems reasonable for you to create this district, but when you go to issue bonds, you're going to review it, the AG is going to review it, the controller's office is going to review it, and the staff is going to go out to that property and they're going to look and they're going to see if utilities are on the ground. And the very first thing that any developer is going to put in the ground is water and wastewater. Now, we're in someone's water CCN and we're applying for a wastewater discharge permit, and that is what the click is here. But that's a separate proceeding. And I agree with the ED that those costs can change at any time. But what is the developer's burden to come back every single day and say, oh, well, now, costs have increased. Well, there's a recession. Now it's different. No, that's what we look at when bond sales come into play. We are not giving a developer a blank check. The developer has to put his or her initial contribution on the ground. That comes out of the developer's pocket. And these are certainly phased-in developments. And I will add that this plant in particular is a lease plant, which a separate third party will build the plant, and that lowers the cost. And that's part of what the discrepancy is. It's a phased cost, it's a lease plant, and that's part of what the discrepancy is. So I don't find the discrepancy to be unreasonable based on the developer's plan. Not a municipal plan, but a developer plan. And so, yes, you may see a discrepancy there, but is that the question? The cost is what the cost is, and the tax burden and the reimbursements will pay the developer what they can, but the developer also has a pocket, and the developer, if he has to, will pay that own money out of his pocket, and that's the developer's risk. There is no risk put on any landowner, because do you think that if a developer, and regardless whether there's a MUD or not, do you think they can sell lots if you don't have water and wastewater?
That's
no.
time.
You can finish your thought if you
Yes,
if you have
and
one to finish.
this is not the threshold question. And if we are looking to these ALJ rulings to upturn the MUD process as it has existed for decades in Texas, then we're just making ad hoc rulemaking. And if we want to change the rules, then let's do it by a formal rulemaking. Let's have some input for all of the requested parties. But this is not a threshold question. This is something that has settled and throughout numerous years of MUD creations.
Thank you, Ms. Scott. Appreciate that. And again, as I was saying earlier, I appreciate all the arguments this morning, the policy arguments. No disagreement. I won't even take a position on them because I don't think I need to get there. And when I'm referring to policy issues, the importance of MUDs, the role that they have served in developing this state's resources and providing housing for the ever-growing number of Texans, the aspirational policies that Ms. Rogers referred to in terms of or maybe the better word is practice than policy, but how does TCEQ scrutinize these applications? I think that's an important line of inquiry too. Again, I don't think it's going to figure into my comments. Getting to the heart of it, we heard the executive director and Ms. Scott really emphasize the fact that this is a moving target, an estimate, and I certainly understand that and appreciate that. I think the word that I would emphasize is reasonableness. Was it reasonable when it was submitted? And Section 54.021 of the Water Code requires us to consider the reasonableness of construction costs among other factors. And I have to agree with the ALJ that the petitioners failed to meet that burden in this case. They failed to demonstrate the reasonableness of the projected construction costs with respect to the proposed wastewater treatment plant. So, colleagues, I agree that denial is the appropriate remedy in this case, and I would also suggest some changes to findings of fact and conclusions of law, but before I jump into that, I just wanted to get your sense of this matter and see if I'm heading in the right direction.
Yeah, I don't have a whole lot of comments. I would just make the comment that a denial is quite rare. These in general, I think going to a contested case hearing, coming back in front of us is quite rare. And, you know, if we adopt the PFD and go towards a denial, that could force a significant change in cost estimate details that the executive director has to consider and use in their justification. Well, and that petitioners have to use in their justification for a petition. But I'm comfortable moving forward with a denial today. I think in this situation, that's the right thing to do, and I think you stated it well, that we're looking at, well, the main issue here for me is the reasonableness of it, and we have to really focus on that word, and so I'm in agreement with you.
Thank you, Commissioner. Commissioner Janeka?
It came down to the record for me. I think you both made great points that align well with where I landed, but where the record is what we're going to need to base our decision on in this matter, it came down exactly how y'all describe it. It's just not, it simply doesn't appear to me that it was a reasonable, successful landing on what would have been defensible cost estimates, given that the record gave, in the ALJ's determination, a more credible range of 29 to 37 million, not 1.75 million. That's a big miss. And I don't think the public derives confidence for us overriding the ALJ, plowing forward, saying the developer will absorb that risk. We're marching directly into the policy perils that the legislature has charged us to guard. And where I was asked to pay $1.75 for something and the bill came back at $30, that would not be reasonable for me for any way, shape, or form. And we did not see the record go to further develop that point, that discrepancy. I think the range of 29 to 37 strikes me as a big cost estimate for what would be reasonable. I think that, so short and sweet version of where I'm at is the record does not support overturning the ALJ's decision. I'm comfortable with denial today as well. And I don't think that it, to Commissioner Lindley's concerns, which I agree with, would be concerning if we really were signaling a departure from where the status quo is. I don't think that we're doing so. I think we're reaffirming what reasonable expectations are for what the public expects to see for these little units of new local government that have very specific, concise boundaries and tax burdens that the public would be asked to assume if they come and live in these spaces. So it's a great tool. It's very valuable for bringing water and wastewater services to parts of Texas where people want to live there, and we see the need. But I think that denial is the appropriate point today.
Thank you, Commissioner. Okay, what I'd like to do is just sort of walk through the findings of fact and conclusions of law that I'm going to suggest that we change. The first topic I want to address is this topic about the wastewater plant cost, and that also relates to capacity. And the first point that I want to make or repeat is we're not asking the applicant or the executive director to keep track of a moving target. The reasonableness of the cost needs to be judged when the petition is submitted. And if material costs or labor costs float up and down after that inquiry, I'm not asking the applicant to come back and prove up something different, or the executive director's staff to keep track of that. In this case, the problem with the cost estimate, I think, really begins with the uncertainty about the capacity of the plant. And the petitioners, as well as the protestants and the ALJs, had some difficulty defining the total capacity. I think it's clear from the record that the capacity, maybe I shouldn't say clear, it was clear to me. I think the record demonstrates that the capacity is 1.587 million gallons per day. And so I would correct finding of fact number 25 accordingly. The record evidence shows that the petitioner's cost evidence of 1.75 million is not reasonable for a 1.587 million gallon per day plant. I would also say, however, that the evidence for the protestant's cost estimate, I thought that was thin to be charitable, so I would simply strike finding of fact number 27 altogether. I would also modify finding of fact 28 to reflect the ALJ's determination that the petitioners did carry their burden with respect to the costs of stormwater facilities. And that was somewhat of a borderline call for me, because I think the petitioners could have made a better showing, but I can certainly live with and would not want to upset the ALJ's determination on that point. So that goes to finding of fact 28, and I'll read that into a motion in just a little bit. The next topic is groundwater levels and recharge. I agree that the petitioners met their burden, but I would point to information in the record relating to the projected impervious cover not having an unreasonable effect on groundwater and recharge. I think that evidence is more relevant to the review of the effects on groundwater level and recharge capacity than the source water of the retail water supply that's proposed for the district. So I would amend finding of fact 32 accordingly. And next, I want to address land elevation and subsidence. This issue is not addressed in the order. I think it probably should be, even though it wasn't a contested item. So I'm going to recommend a new finding of fact to reflect that the petitioner did present sufficient evidence to meet its burden, and suggest that we amend conclusion of law 7 to add land elevation and subsidence to the list of considerations. And then finally, the last nitpick that I have is on conclusion of law 13. It cites an agency rule that addresses the content requirements for preliminary engineering reports submitted in support of water district petitions. And that's different from the legal standard under the Water Code at Chapter 54 against which petitions are evaluated. So in other words, that rule does not provide a separate or distinct or additional burden to Chapter 54. So I would keep the conclusion, but just strike the rule citation, because we really look to the statute and not to that rule. Is that sufficiently clear for me to attempt a motion, colleagues?
I'm comfortable.
I believe so.
Okay. Then I'm going to go ahead and move that we adopt the administrative law judge's proposed order with the following changes. Amend finding of fact number 25 to change the total wastewater capacity needed from 1.56 million gallons per day to 1.587 million gallons to more accurately reflect the testimony and evidence in the record. I'll further move that we delete finding of fact number 27 because it is not supported by the evidentiary record, which includes only conclusory testimony from all parties. To memorialize the applicant's other estimated construction costs, including the stormwater facilities costs, were recommended by the ALJs to be reasonable, modify finding of fact number 28 to state, quote, the applicant provided sufficient evidence to establish that the estimated construction costs for all other facilities besides the wastewater treatment plant are reasonable, end quote. To clarify that the commission does not consider the proposed district's water supply source to be a consideration for the groundwater issue, and to identify the record evidence that the commission finds better supports the groundwater factor analysis, delete proposed finding of fact number 32, and replace it with the following, quote, "The proposed developments resulting impervious cover from mostly single-family residential lots will not have any greater effect on groundwater levels or recharge capacity of groundwater in the region than any other typical single-family development." To address all 7 statutory factors within the commission's review, add new finding of fact number 53 to state, quote, "The districts, their systems, and subsequent development will not have an unreasonable effect on land elevation and subsidence," end quote. Amend proposed conclusion of law number 7 to add, quote, "land elevation and subsidence," end quote, into the list of issues to memorialize that the record supports concluding that the districts, their systems, and subsequent development will not have an unreasonable effect on land elevation and subsidence under Texas Water Code Section 54.021B3A and B. And finally, I move that we amend proposed conclusion of law number 13 by removing the regulatory site to 30 Texas Administrative Code, Section 293.11D5J, to emphasize that the regulatory preliminary engineering report content requirements are not a separate burden from the necessary statutory determination.
So a quick, on your first item for amending finding of fact number 25, you were talking about changing the need from 1.56 million gallons per day to 1.587 million gallons, but I assume you mean per day on that one too?
Yes.
Okay.
Yeah. Thanks for the clarification. Colleagues, how's that sound? That's my motion.
I would second that.
I'm in agreement with that.
All
motion as
right.
amended.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. Motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 3 is the consideration of the application for amendment and renewal of air quality permit number 41945 by BASF Total Energies Petrochemicals LLC. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So, colleagues, as you know, Chapter 55 of our rules provides a 2-part analysis for considering requests for contested cases on this type of application. First, we consider whether the requesters have met the procedural and substantive requirements to be entitled to a contested case. And assuming that at least one requester meets the requirements, then we consider which issues are appropriate to refer to hearing. Requesters who are affected in a manner different from the general public and who make timely comments articulating personal concerns that are relevant and material to the application and who express those concerns in a timely hearing request are entitled to a hearing. Associations can have standing if, among other requirements, they identify a member who would have standing in their own right. And colleagues, on this item, we have a single request from Mr. Hilton Kelly and the Community Empowered Development Association. The request identifies relevant concerns about health effects. It provides an address for Mr. Kelly that's over 6 miles from the facility, and it states that Mr. Kelly works, frequents a restaurant, and otherwise visits areas near the plant on a routine basis. And colleagues, on this item, I agree with the Executive Director and OPIC that Mr. Kelly has not identified a personal justiciable interest different from the general public and is therefore not entitled to a hearing. And because Mr. Kelly is the only identified member of CETA, CETA also lacks standing, so I would deny the request.
I'm in agreement.
I see it the same way, and I have a motion. I would move that we deny the hearing requests of Hilton Kelly and Community and Power and Development Association Incorporated, that we issue the amendment and renewal of air quality permit number 41945 to BASF Total Energies Petrochemicals LLC as recommended by the executive director, and we adopt the executive director's response to public comment.
A second?
The motion has been made and seconded. All those in favor say aye.
Aye.
Motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 4 is the consideration and approval of the TCEQ Chief Auditor's Office Annual Risk Assessment and Fiscal Year 2024 Audit Plan. The Executive Director, or I'm sorry, the Chief Auditor is here.
Good morning, Mr. Hardison.
present.
Good morning, Chairman Ehrman, Commissioner Lindley, Commissioner Janeka, General Counsel, Public Interest Counsel. For the record, my name is Mike Hardison. I'm the Chief Auditor of the TCEQ. With me today is Kelly Smith, a Senior Auditor and Project Manager in my office. I'm here today to present and ask approval of the Annual Risk Assessment and Fiscal 2024 Audit Plan prepared by my office. Chapter 2102 of the Texas Government Code requires the Chief Auditor to prepare a risk-based audit plan annually, and that plan be approved by the Commission. In order to identify a risk facing the agency and develop a plan to address those risks, my staff and I conducted interviews with individuals charged with governance and other selected TCEQ management and staff. We also provided surveys to TCEQ division managers that were not interviewed individually. We reviewed external reports for audits of agency processes. We performed financial analysis related to funding and expenditures. We reviewed and evaluated turnover and staffing issues, and then used those attributes to risk rank concerns identified to our office. The plan before you outlines our planned efforts to address those risks identified during the process. And at this time, I'd ask your approval of the plan, and I'm here to answer any questions you may have.
Thank you, Mr. Hardison. I have none at this point. Colleagues, any questions?
No.
Ms. Smith, has anybody signed in to speak on this item?
No one has signed in.
All right, and Mr. Arthur, what says OPIC?
Good morning, Chairman, and good morning, Commissioners. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. OPIC supports approval of the FY 2024 Annual Risk Assessment and Audit Plan as recommended by the Chief Auditor.
Thank you. I just have a few comments, Mr. Hardison. The first one I want to emphasize is that this plan is a living document. It can be amended. If any TCEQ employee has any concern about risk to this agency, certainly I would really appreciate it if you bring it to my attention, my office, or if not me, to Mr. Hardison and his team. We can change the plan to address the risks that are most pressing to this agency. What the plan represents is our best judgment of what those risks are now in terms of prioritizing them. The next thing I want to say is, Mr. Hardison, to you and your team, thank you very much for the outstanding work you do for the agency. I really appreciate it. The audit plan looks good to me where we are right now, and colleagues, I'm ready to move forward with it.
Thank you.
As am I.
Likewise, I'd like my chance to ladle on a little praise as well. I wanted to suggest to Mr. Hardison we may want to improve on this planning step. I notice you talk about quality control. You acknowledge the peer review, and the most recent one that we just had this past year. I'm eager to find a way for us to assess our audit program in a way that we can not too audaciously about it, but we need to brag on ourselves, because as I understand it, you are way outperforming your colleagues in the state agency audit function among agencies not just of our size, comparable agencies, but those of much larger size, scale, and budget. You still, on a comparable pound for pound blow other agencies out of the water. And I really appreciate how much value that brings to our agency, which is mired in technical problems and questions and controversial political public issues that the audit function is rock solid. And I really appreciate how much that strengthens our agency's regulatory posture with regards to our mission. And nothing more to say further, just thank you.
And they do all that with their own vacancy issues, or have done it, so kudos as well. I can make a motion if we're ready. Okay, I would move that we approve the Chief Auditor's Office Fiscal Year 2024 Annual Risk Assessment and Audit Plan as recommended by the Chief Auditor.
Seconded.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 5 is the consideration and approval of the agency's fiscal year 2024 operating budget, including salary increases for scheduled exempt positions that require approval under the General Appropriations Act. The Executive Director's staff is here to present this item.
Good morning.
Good morning. Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I'm Janae Burse, Deputy Director of the Budget and Planning Division. Stephanie Robinson and I will present the Interim Executive Director's recommended fiscal year 2024 operating budget. This information was compiled in accordance with the General Appropriations Act. Turning to page 1 of the FY 24 operating budget. On page 1, it shows the total budget for FY 2024 is $559 million compared to the FY 2023 budget of $533 million. This is an increase of $26 million, or 5%. This increase is mostly attributed to the exceptional item requests, leaking water wells grant program, and the TCEQ's sunset review. The number of FTEs has increased by 55 and is mainly attributed to the additional FTEs for the Safety at Storage Vessels program, exceptional item requests, and the TCEQ sunset review. Included in our baseline is $1.4 million appropriated from the TERP account 5071 for temporary cash flow needs. As this appropriation is to be returned, it is not included on subsequent slides of the presentation. Turning to page 2. Page 2 provides an illustration of the method of finance for fiscal year 2024, which reflects appropriated fee funds at 54% and TERP fee funds at 30% of the total budget, with the total fee funds comprising 84% of the total budget. Stephanie Robinson will now provide an overview by office.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I'm Stephanie Robinson, Assistant Deputy Director of Budget and Planning Division. Continuing on page 3, the allocations of FTEs by office is provided. The number of FTEs has increased by 55 and is mainly attributed to the Safety at Storage Vessels program, exceptional item request, and sunset review. On page 4, we provide a comparison of the budget by office. The largest percentage change is related to agency-wide, which is mainly attributed to budgeting for funding for the targeted salary increase, exceptional item request, the leaking water wells program, and the portion of the TERP admin that's currently under the administrative cap pending implementation. On the following page 5, we provide a comparison of the budget by category. The largest percentage change is related to other operating, which has increased by $22 million, or 25%, which is mainly attributed to professional temporary services and other operating. And on page 5, we provide a list of programs supporting remediation, reimbursement, and grant contracts. With the next 2 pages on 7 and 8 providing a detail of our capital budget. And page 9 provides a summary of the estimated budget for the TERP programs. And this table is based on current revenue and program need estimates. And our final page provides a summary of the exempt position salaries. And this concludes our presentation. We request your approval of the recommended FY 2024 operating budget and to increase the salaries of TCEQ exempt positions to the amount authorized by the 88th Legislature in House Bill 1. Thank you, and I'm available for questions.
Thank you. Appreciate the presentation. I have none. Colleagues, any questions?
I don't have any questions, but I have a comment. Can't talk about budget and give me a microphone because I'll have to speak. I really just a big thank you. You know, we budget and planning. Everyone in OAS with budget and planning, since y'all are in front of us today, y'all do so much behind the scenes, and y'all geared us up for session. And you know, I know there's a level of disappointment that we didn't get all of our exceptional item number 1, but we did get a lot of money that will benefit the employees of our agency, and y'all were able to get us that number. I don't even know how much number crunching y'all had to do in order to get us the data we needed, but that data and then all the hard work of our employees are what got it. And so I think this is the only time y'all come in front of us. So I just want to thank you very, very much for the work y'all do, because it gears us up to be successful in the legislative session. And because y'all and because our financial division are smart and wise with our money and good stewards of the money we get, we are able to be, I will just say, I think because we've been good with our money, the legislature felt comfortable giving us more. And so kudos to all the people that worked on that going into the legislative session. But then I know it's all year round, and especially the month of August. So thank y'all. That's all.
Thank you, Commissioner. I echo the gratitude. Commissioner Ginecca.
Thank you. I'll add on to Commissioner Lindley's point. It reminded me, happy belated new fiscal year, or coming soon. To those of you who celebrate, this is the part of our agency that most acutely feels that fiscal year cyclical nature of it. I second that. And I think just to make one point further on Commissioner Lindley's point, I think the good work that y'all have done in supporting our request to the legislature for those exceptional item dollars, in my opinion, we can't speak for tomorrow, and we can't speak for any agency, any commission's future decision, but when we make our legislative appropriation request for the next biennium, for the next round before the legislature, I'm having a hard time imagining all the technical arguments that we made. I'm not sure that those are going to erode in my mind, that we're going to still continue to feel strongly that we need adequate compensation for our staff, and we've seen the needs firsthand. We're doing everything we can. I heard firsthand this last week about an anecdote of a staffer who was on their way out the door to a different state agency and turned back around when they learned the coming work posture, telework posture expectations in that agency relative to where ours was reasonably comfortably stretched out a little more flexibly in their mind, where that pulled them back. We don't have every tool at our disposal. So to this document representing a slice of the tremendous work y'all did in deciding on how to allocate that partial appropriation we got for the staff salaries, I really am pleased. And I hope that y'all have heard words of thanks and encouragement from the other staff in the agency as we continue to interact with each other in the evolving posture we're at. Sometimes that happens in different times during the year, but for what it's worth right now and the chance we have while it's before us, thank you.
Thank you, Commissioner. Ms. Smith, has anybody signed in to speak?
No one signed in.
And let's hear next from Mr. Arthur.
Chairman, Commissioners, OPIC shares the Commission's appreciation, and we support approval of the FY 2024 operating budget as proposed by the ED.
Thank you. I've reviewed the budget. I've been briefed on it, as well as the exempt position raises. Colleagues, I'm ready to move forward.
I move that we approve the fiscal year 2024 operating budget as recommended by the Executive Director and approve the salary increases for fiscal year 2024 for scheduled exempt positions as listed in Article 6 of the 88th Legislature's General Appropriations Act.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item 6 is the consideration of material changes to contracts for goods and services awarded under Chapter 2155 of the Texas Government Code, executed between March 1st and May 31st, 2023. And the Executive Director's staff is here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Roger Doobie, Purchasing Supervisor of the Financial Administration Division. I have with me Chris Gobert, Procurements and Contracts Manager of the Financial Administration Division. We are representing the Executive Director. This item contains some material changes made for the contracts and purchases for goods and services between March 1st, 2023 through March 31st, 2023. Reported material changes include extensions of the contract or completion of work for 6 months or more, or an increase in consideration of 10% or more. In accordance with Section 22155.088 of the Government Code, the Executive Director presents these items for your consideration. I'm available to answer any questions you may have.
Thank you, Mr. Doobie. I have none. Colleagues, any questions?
No questions. I just hope you heard my shout out to the Financial Division as well in that last item.
Ms. Smith, has anybody signed in to speak on this item?
No one is registered.
Mr. Arthur, what do you think?
OPIC supports approval and issuance of the ED's proposed resolution to acknowledge material changes to contracts for goods and services in accordance with Texas Government Code, Section 2155.088.
Thank you. Colleagues, I agree. I've reviewed these items and I'm ready to acknowledge them.
I agree. I would move that we approve issuance of the Executive Director's proposed resolution acknowledging the material changes to contracts for goods and services in accordance with Texas Government Code, Section 2155.088, as described in the TCEQ Interoffice Memorandum to the Commissioners and Interim Executive Director dated August 16, 2023, in docket number 2023-0744-MIS.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item 7 is the consideration of gifts and donations of $500 or more in value given to TCEQ, submitted for approval in accordance with Chapter 575 of the Texas Government Code concerning acceptance of gifts and donations by certain state agencies. And the Executive Director's staff is here to present this item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Yen Tran of the General Law Division, representing the Executive Director. Before you are the gifts and donations received by the agency in the past 90 days. In accordance with Chapter 575 of the Government Code, the Executive Director has accepted these gifts and respectfully requests your acknowledgement of these gifts. As always, I'm available to answer any questions you may have about these items.
Thank you, Ms. Tran. I have none. Any questions, colleagues?
No questions.
No questions in particular, other than to point out, it was nice of you not to point out I'm the biggest ticket item on the list. This particular item, this docket, it was reimbursed by one of our federal colleagues. But thank you for leaving that fact off from the mic.
You're welcome.
Ms. Smith, has anybody signed in to speak?
No one is registered.
Mr. Arthur, did you scrutinize Commissioner Janeka's travel?
It did stand out to me. No, I'm just kidding. OPIC supports approval and issuance of the resolution acknowledging the ED's acceptance of gifts and donations.
Thank you. I've reviewed these items, including the Commissioner's travel. Certainly appreciate the donors' generosity in supporting our agency's mission. Colleagues, I'm ready to move forward.
Yes, am
I move that we approve issuance of the resolution acknowledging the Executive Director's acceptance of the gifts and donations contained in the TCEQ Interoffice Memorandum to the Commissioners dated July 28, 2023, docket number 2023-0807-MIS.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 8 is the consideration of a resolution reauthorizing the Executive Director to enter and manage all contracts, including grant agreements, and to delegate authority to certain staff. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Chairman,
Commissioners, General Counsel, and Public Interest Counsel. My name is Angela Burnett, Staff Attorney with the General Law Division, representing the Executive Director. This item relates to the administration of contracts and grants on behalf of the Commission. Chapter 5 of the Texas Water Code authorizes the Executive Director to manage the administrative affairs of the Commission under the general supervision and direction of the Commission. Specifically, Section 5.229 authorizes the Executive Director, with the consent of the Commission, to negotiate and enter contracts and other agreements with various entities, including the United States and its agencies, states and Texas political subdivisions, or with any other entity to carry out the Commission's powers, duties, and responsibilities. Section 5.124 of the Water Code authorizes the Executive Director, with the consent of the Commission, to award grants for any resource conservation or environmental protection purpose. Section 2261.254 of the Texas Government Code permits the Commission to authorize the Executive Director to approve and sign contracts for the purchase of goods and services that are valued over $1 million. This section also allows the Deputy Executive Director to sign contracts over $1 million. For efficiency in making payments, the Texas Comptroller of Public Accounts allows the governing body of a state agency to authorize the agency's executive director to designate one or more individuals to approve the agency's payment documents pursuant to 34 Texas Administrative Code, Section 5.61H1. The resolution would allow the executive director to delegate all contract authority to the deputy executive director and other agency staff. The Commission retains oversight of contracts and grants through two existing practices: selected contracts briefings on a quarterly and on an as-needed basis from the executive director and staff, including reporting by the Financial Administration Division for contracts of $5 million or more, with risk related to the solicitation. GLD briefings include contracts that are expected to exceed $3 million, or for mission-critical work, or have commission or public interest such as significant risk for injuries, property damage, or failure of performance, significant impacts on agency resources, or significant financial, legal, or public policy concerns. In addition, there are quarterly agenda items to consider material changes to contracts pursuant to Section 2155.088 of the Texas Government Code. The proposed resolution delegates authority to the Executive Director for these purposes through August 31st, 2025, continuing authority previously granted in Resolution 2021-0940-RES, issued August 19th, 2021. The Executive Director respectfully requests your approval of the proposed resolution, and I'm available for any questions.
Thank you, Ms. Burnett. I have none. Any questions, colleagues?
No.
Seeing none, Ms. Smith, is anybody signed in to speak?
No one is signed in.
Thank you. Mr. Arthur.
OPIC supports adoption of the contract delegation resolution as recommended by the ED.
Thank you. Colleagues, I've reviewed this item and the resolution. I'm ready to move forward.
As am I. Excuse me. I would move that we adopt the contract delegation resolution as recommended by the Executive Director.
Second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 9 is the consideration of the publication and solicitation of public comment on the Executive Director's proposal to adopt a target cancer risk level of 1 in 100,000 for setting screening levels that are used in TCEQ's air permitting program and that are compared to ambient air monitoring data. The Executive Director's staff is here to present this item.
Good morning, Dr. Lang.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Dr. Sabina Lang, and I am the Chief Toxicologist at the TCEQ. I am appearing here this morning on behalf of the Executive Director. With me is Tammy Mitchell from the Office of Legal Services. The Executive Director has completed a proposal to use a target cancer risk level of 1 in 100,000, or 1 times 10 to the minus 5, for setting screening levels that are used in TCEQ's air permitting program and for comparison to ambient air monitoring data. This proposal is being directed to the Commission with a request to post for 30 days of public comment. This proposal implements the Sunset Advisory Commission's Management Action Recommendation 1.2, detailed in that Commission's staff report. Target cancer risk levels represent levels of cancer-causing chemicals that are considered to confer no significant risk from long-term exposure. These risk levels are set by policymakers and risk managers as a necessary step in the risk-based decision-making process of developing cleanup levels, which determine what concentrations of chemicals must be removed when cleaning up a contaminated site, and screening levels, which determine what concentrations of chemical require additional investigation when encountered. Based on this target risk level, the risk assessor can then establish the long-term health protective concentration of a chemical in a given environmental media, such as air, soil, or water. Texas has set a target cancer risk level of 1 in 100,000 for the Texas Risk Reduction Program, or TERP, for site remediation, and for the Texas Surface Water Quality Standards, as set out in 30 Texas Administrative Code, Chapter 307. This same risk level has been applied since 2006 when setting screening levels for use with the air permitting program and for comparison to ambient air monitoring data, but its use was not specifically discussed by this commission. The executive director respectfully requests your approval to release the draft proposal for 30 days of public comment, and I'd like to thank you for your consideration, and I'm available to take any questions.
Thank you, Dr. Lang. I have none. Any questions, colleagues?
No.
I'm just curious what style the request for public comment will take. Is it in the Texas Register, on our agency website? What specifically?
It'll be both. So we'll put it into the Texas Register, put it onto our website, and send it out. The Toxicology Division has a listserv that we send out to interested parties, other members of the toxicology and risk assessment community. So all of those will be used to send this for public comment.
Excellent. Thank you.
Appreciate the question, Commissioner. Thank you, Dr. Lang. Ms. Smith, has anybody signed in to speak?
No one has signed in on this one.
Okay, and Mr. Arthur, what do you think?
OPIC supports the 30-day posting and solicitation of public comments on the ED's proposed target risk level.
Thank you, colleagues. I'm ready to receive public comment on this and am ready to move forward with proposal.
Me too.
I will move that we adopt the publication and solicitation of public comment on I will move to approve the publication and solicitation of public comment on the adoption of a target cancer risk level of 1 in 100,000 as recommended by the executive director.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 10 is the consideration for approval of the draft implementation plan for 4 draft total maximum daily loads for indicator bacteria in tributaries of the Neches River below Lake Palestine. The executive director's staff is here to present this item.
Good morning, Ms. Hall.
Good morning. Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I am Nicole Hall with the Water Quality Planning Division in the Office of Water. With me today are Wyatt Eason with the Total Maximum Daily Load Program and Bobby Salahi with the Environmental Law Division. Today, the Executive Director is requesting the final approval of the implementation plan for 4 total maximum daily loads for indicator bacteria in tributaries of the Neches River below Lake Palestine. The I-Plan covers 4 assessment units in 4 water bodies within Angelina County. A stakeholder group was formed with balanced representation of all interested parties and was tasked with providing input on the I-Plan document. The development of this document included an active public participation effort and balanced stakeholder group coordinated by TCEQ and the Texas Water Resources Institute. The success of this project is due to the collaborative effort of the individuals and organizations that put in the time to develop this document to improve water quality in their community. The Executive Director respectfully requests approval of the implementation plan. Permission is also requested to make non-substantive and clerical corrections if needed. Thank you, and we are available to answer any questions that you have.
Thank you, Ms. Hall. I have none. Any questions, colleagues?
No, thank you.
Ms. Smith, has anybody signed in to speak?
No one on this one either.
All right, Mr. Arthur.
OPIC supports approval of the implementation plan for 4 TMDLs for indicator bacteria and tributaries of the Neches River below Lake Palestine.
Thank you. I do too. I want to thank our staff, our stakeholders for their help in developing this plan, the Texas Water Resources Institute for their support. One of the important measures in this plan is monitoring of water quality. So I want to thank the Texas Stream team and all of their volunteers and encourage others to become involved in that project if they have an interest in it, and the Meadows Center for managing all the data. So with that gratitude out of the way, colleagues, I'm ready to adopt the I-Plan.
Same. I would move that we approve the implementation plan for 4 draft total maximum daily loads for indicator bacteria in tributaries of the Neches River below Lake Palestine as recommended by the executive director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item number 11 is the consideration for approval of the implementation plan for 5 total maximum daily loads for indicator bacteria in Hillebrand Bayou and Neches River tidal in the Neches Trinity Coastal Basin and Neches River Basin. The Executive Director's staff is here to present this item.
Good morning again.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I am Nicole Hall with the Water Quality Planning Division in the Office of Water. With me today are Wyatt Eason with the Total Maximum Daily Load Program and Bobby Salahi with the Environmental Law Division. Today, the Executive Director is requesting the final approval of the implementation plan for 5 total maximum daily loads for indicator bacteria in Hillebrand Bayou and Neches River tidal. The I-Plan covers 5 assessment units in 2 water bodies within Jasper, Jefferson, and Orange counties. A stakeholder group was formed with balanced representation of all interested parties and was tasked with providing input on the I-Plan document. The development of this document included an active public participation effort and balanced stakeholder group coordinated by TCQ and the Texas Water Resources Institute. The success of this project is due to the collaborative effort of the individuals and organizations that put in the time to develop this document to improve water quality in their community. The Executive Director respectfully requests approval of the implementation plan. Permission is also requested to make non-substantive and clerical corrections if needed. Thank you, and we are available to answer any questions that you have.
Thank you again, Ms. Hall. Colleagues, any questions? Seeing none. Ms. Smith, is anybody signed in to speak?
No.
Mr. Arthur.
OPIC supports approval of the implementation plan for 5 TMDLs for indicator bacteria in Hillebrand Bayou and Neches River tidal.
Thank you. I just reiterate the thanks that I expressed on item 10. It's largely the same cast of characters with maybe some additional or different stakeholders. And colleagues, I'm ready to adopt this I-Plan.
Me too.
Likewise, I move that we approve the implementation plan for 5 total maximum daily loads for indicator bacteria in Hillebrand Bayou and the Neches River tidal as recommended by the Executive Director.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next items.
That brings us to our enforcement docket, which is items 12 through 56. The Executive Director's staff is here to present.
Good morning, Ms. Cordell.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Michael Parrish, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division representing the Executive Director. Pending before you are items 12 through 56. The total assessed administrative penalties are $1,267,176, with $156,531 deferred, $336,702 applied towards supplemental environmental projects, and $773,943 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Colleagues, any questions?
No questions.
Seeing none, Ms. Smith, has anybody signed in to speak on any of these items?
No one has asked to address the commission. However, on items 16 through 19, 21 through 26, and 29 through 31, we have folks registered who are available to answer questions if the commission has any.
Thank you. And Mr. Arthur, what is OPIC's perspective?
OPIC supports adoption of these enforcement orders as presented by ED staff.
Thank you. Colleagues, I do too. I'm ready to move forward with this docket.
As am I. And I would move that we adopt items 12 through 56 as recommended by the executive director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item 57 is consideration of the monthly enforcement report, and the executive director's staff is here to present.
Good morning again.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me are Michael Parrish of the Enforcement Division and Gitanjali Yadav of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2023 through June. There were 797 effective administrative orders issued, and of those, 100 contained supplemental environmental projects. These orders assessed a total of $10,346,752 in penalties, with a payable amount of $6,198,622. $2,652,610 are to be paid towards supplemental environmental projects. 11,891 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 1,719 enforcement action referrals have been received. There are 2,323 pending administrative orders with 1,219 cases that are on the backlog. 179 cases are pending at the Attorney General's office for representation in district court, and 14 judgments have been issued. 2,241 cases are being tracked for compliance. We have included for review a summary of OCE investigative activities for fiscal years 2021, 22, and 23. We are available to answer any questions you may have.
Thank you, Ms. Cordell. Colleagues, any questions? Ms. Smith, has anybody signed in to speak?
No.
Mr. Arthur?
OPIC has no comment except to say we appreciate the report.
I do too. Colleagues, there's no final action necessary on this item. Thank you. Ms. Smith, when you're ready, I'll ask you to please call the next items.
So that takes us to our items 58 through 61, which are the quadrennial rule reviews for chapters 117, 318, 327, and 332 of the Texas Administrative Code. Title 30, the executive director's staff is here to present these matters.
Good morning, Ms. Rico.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Gwen Rico with the General Law Division. Pending before you are items 58, 59, 60, and 61, the adopted rule reviews of 30 Texas Administrative Code, Chapter 117, Control of Air Pollution from Nitrogen Compounds, Chapter 318, Marine Seawater Desalination Discharges, 327, Spill Prevention and Control, and Chapters 332, Composting. As required by Texas Government Code Sections 2001.039, Executive Director's staff conducted a rule review of these chapters to determine if the need for the rules within these chapters continues to exist. The proposed notices of the reviews for 30 TAC Chapters 117, 318, 327, and 332 published in the April 7th, 2023 issue with a 30-day comment period. No comments were received. Based on the review of these chapters, the Executive Director has determined that the reasons for the rules in Chapters 117, 318, 327, and 332 continue to exist, and changes to the rules identified as part of this review process may be addressed in a separate rulemaking action in accordance with the Texas Administrative Procedure Act. In conclusion, we respectfully recommend approval of the adoption of the rule reviews of 30 TAC Chapters 117, 318, 327, and 332. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with the Texas Register requirements. Thank you. The project managers and attorneys assigned to these chapters are here to answer any questions.
Thank you, Ms. Rico. I have none. Colleagues, any questions?
No, thank you.
Ms. Smith, has anybody signed in to speak?
No.
Mr. Arthur, what is OPIC's perspective?
OPIC agrees that the reasons for initially adopting the Chapter 117, 318, 327, and 332 rules continue to exist, and we support readoption of the rules in each chapter.
Colleagues, I agree with all of that. In addition, we should initiate rulemaking to remove the obsolete provisions identified in Chapter 117. And with that, I think I'm ready for a motion.
I move that we adopt the rule reviews and readopt the rules in 30 Texas Administrative Code, Chapters 117, 318, 327, and 332 without amendment, and initiate a rulemaking to evaluate the repeal or amendment of sections of Chapter 117 that were identified as potentially obsolete or outdated, as recommended by the Executive Director.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next items.
Items 62 through 65 are for closed session, and the commission will meet in closed session in Building E, Room 211S at, say, 11:50, as permitted by the Open Meetings Act, including Texas Government Code, Sections 551071 and 551074, to take up and consider matters pursuant to these items as posted and noticed.
The time is 11:46 a.m. We are in recess.
The commission met in Building E, Room 211S for closed session from 11:52 a.m. until 12:38 p.m. on item number 63 through 65 as posted in notice pursuant to Government Code Section 551074. No action was taken. This agenda stands adjourned and the time is 12:41.